Good day, liberators and fellow citizens of the world. I haven't put out a video for quite some time now, and I do apologize, but the reason for that is, above others, that the past month alone, we've lodged not less than 4 court applications against the state for overreaching of power. And the purpose of this video is to just give a quick feedback on each one of these cases, why we've lodged those applications, and also to just tell the public that, remember that Liberty Fighters Network is not a group of legal practitioners. For that reason, we are not entitled to, at the end of the day, of all these cases that we are pursuing for the liberties and for the benefit of our people, for all of us, we are not going to receive a cost order that's going to be taxed and then we can get millions from the state. We are not an AfriForum who's got the benefit of benefactors who's funding them, and then or the legal teams, and then at the end of the day, their legal teams can get all the money and the benefits. So we are just relying on voluntary donations from our supporters. So I'm just asking that if you support Liberty Fighters Network and what we are doing, remember that we are doing this full time. This is our job. I know that there are some people on social media saying that I must get a job. This is my job. To fight for your liberties, and so please consider that we also have to pay our overheads. So those of you who can and who's willing, you're not forced. Try and consider just to help us going with a voluntary donation or a gift of some sort. Go to our website. Under donations, there's actually a wish list of things that you might help us with. So consider that as well. Okay, let me just start off with the first case. And if you wait until the end of this video, I will reveal 2 other cases that we're going to lodge soon. That's linked to this and that you might find very interesting. Let me start off with the first one, the case against the Minister of Agriculture, John Steenhuisen. John Steenhuisen is the leader of the DA. We've sent him a letter previously to say that he has to reveal his record concerning his decision on vaccinating poultry in South Africa. And irrespective of the fact that the DA has been criticizing the ANC for many years for not being transparent, John Steenhuisen declined to provide us with that record. So if he had nothing to hide, why did he not just give us that record? So now we had to go to court and get that record and ask the court, based on the record that we're going to receive, whether his decision has to be reviewed and set aside. What frustrates me a lot is the fact that after 31 years, it does appear that the state still does not have a process of documenting their decision-making processes properly. I would have expected that with each and every decision that the state is taking, and I'm referring to the state, not the government, because government is the process or the work of governing. So it's actually incorrect to refer to the state as the government. But leave it as it may. I would have expected that after these years, I would have had a repository so that whenever you want a decision record, then they can just say, no problem, here it is, give it to you. But now, when you ask them to please provide it to us, then they don't have it. So it's literally thumbs up, and the record is only created the moment when it's queried. So John Steenhuisen allegedly is now busy producing his record of decision, which he should have kept from the very beginning, to now be forced to provide it to us through this court process. I don't know at this stage what the record says. I've had professionals, specifically in poultry, veterinary surgeon specializing in poultry, who came to me and said that he agrees with the fact that the decision was not properly taken, but according to him, the vaccination of the poultry is extremely safe for human consumption. If that is the main reason why we're doing this, I can't say anything about that at this stage before I have the record at hand to study. So an expert who has been following Liberty Fighters Network since 2020, when we became known for challenging the lockdown then, he came out to say that he supports us, but as an expert in the field, he can guarantee us that that the vaccines that specifically used, if it can be called vaccines, used on poultry specifically at this point in time, does not affect human consumption. Let's see what the record reveals. Then the second one is the challenge of the COVID-19 national state of disaster when it ended. This is a very important court case because of the fact that, as you know, we've been challenging the lockdown since the very beginning, and we probably the only organization still left who's pursuing this, although it's now 5 years since the national state of disaster was first declared. We've got other court cases already connected to the national state of disaster and COVID-19 alleged pandemic, and so we are pursuing those. But irrespective, we are sure that from new evidence that we have obtained, that the national state of disaster ended on the 14th of June 2020. That is because we've got access to a specific constitutional court case which specifically deals with the meaning of what a month is in law. And when you use that definition of and that interpretation of the Constitutional Court, one would have seen that the extension that was made on the 5th of June for another 3 months, or on the 5th of June, the Minister of Cooperative Governance and Traditional Affairs at that point in time, Dlamini Zuma, she said that irrespective the initial 3 months that the national state of disaster may proceed and endure, she's going to extend it for another month after it's going to lapse. And that extension that she made on the 5th of June referred to up till the 15th of July. And at that point in time, it should have actually, according to us, have been the 13th of July. The fact that that is a legislative prescription, it's mandatory, it had to have been properly met, wasn't. And it's not something that the court or anyone could have condoned. So the extension that she published on the 5th of June is fatally flawed and invalid. So we'll keep you up to date, and the repercussions of this resultantly, if we are successful, which we do believe the court must give us this one, because if the High Court is not going to side with us, it means that they are not following a constitutional court ruling. And when the High Court does side with us, then we've made provision for a class action to be certified, whereby everyone of the members of the public who suffered, lost their jobs, lost income in any way, may then submit a claim for damages against the state. Where are we going to get the money? Don't you worry about that. The state does have the money. The state does have the resources to compensate anyone who's going to put in a claim and which is going to be accepted. And yeah, we must just deal with it at that point in time. To now presume that, we are bankrupt. I totally disagree with the fact that South Africa is bankrupt. I think that it's a mere media narrative that's being pushed, and that South Africa has quite a lot of resources. They've got other means to compensate us. For example, giving land to those. The government has got, the state has got a lot of land, for example. So with my claim that I'm going to put in, I might even settle to say, okay, just give me a piece of your land that's apparently on your books, etc., etc., etc. There's far more than enough land to give to each and every one of our citizens. It's not that there's not any assets, but we'll meet it. We'll get to that point. Then the third one that we have lodged is our challenge to the International Health Regulations Act. That goes hand in hand with the World Health Organization international health regulations that have been approved last year already, or have been decided on last year. South Africa has not. It was approved by consensus, meaning that no one has put up their hands. It's just that there was no objection to it. And whether our constitution allows decisions to be taken by way of consensus, that is one of the questions we would like to answer. And then, in order for the World Health Organization, international health regulations, to become law in South Africa, we physically in South Africa have to incorporate it into our law. So, and specific processes, parliamentary processes have to be followed, and also consultation processes with the public. So it's incorrect to say that it's automatically, the moment, because it's there, we can automatically use it. That's not the case. In South Africa specifically, we've got the National Health Regulations Act of 1974, which says that the president, and I will get to that point, can incorporate by regulations that he's going to publish, can incorporate those international health regulations into the legislative books of South Africa. So he can do it. Later on, during the later 80s, I think in 1986 or so, there was an act of parliament which have actually transferred that responsibility from the president to the Minister of National Health and Population Development. We don't have that office in South Africa. So who is actually responsible for that? If it is that the Minister of Health is suddenly going to take that job and put in the regulation, we are fighting the constitutionality of that act to say that you cannot allow a minister or a member of the cabinet, even the president, to just incorporate law of that nature in South Africa, and we must stick with it. There must be a proper parliamentary oversight. There must be a consultative process going on. So we have decided, instead of attacking the International Health Regulations Act or regulations, and the fact that we have agreed to it in consensus, and we still don't know whether South Africa has agreed to it or not. Very interesting is that, irrespective of the fact that the International Health Regulations Act only incorporates, I think, up till the 1969 World Health Organization International Health Regulations. I'm talking under correction. I don't have the documents with me now, but what's interesting is that the 2005 amendments have never been incorporated into South African law. So factually, we were not obliged to follow the 2005 International Health Regulations in any event. So for us to say, oh, we are following that, that's not correct, because otherwise the 2005 would have been incorporated into our legislation, and it's very highly unlikely that the president or the government, the state, is now going to incorporate the new amendments of 2024, based on the fact that we have not even done the 2005 yet. So I will keep you posted on that, but it's important for us to challenge it and get the factual background and the records, everything. And then a very important one also for the people is the challenge of the draft admission of learners to public schools that have been published by the Minister of Basic Education, also a Minister of from the DA, Quebera, and Quera, sorry. And she has blatantly defied the act itself. And I know that people are saying that this is Bella regulations. It's not Bella regulations. It's the South African Schools Act regulations. Bella have amended the South African Schools Act. And strangely enough, as everyone hated the Bella Act, the Bella Act have actually incorporated Section 5.1, made changes to Section 5 of the South African Schools Act, and incorporated Section 5.1a, in which specifically the Bella Act amendment have now made provision that even if you do not submit any required document, you may not be refused access to a school. So how can the minister make draft regulations that's automatically conflicting with the act itself? So on that basis alone, we are saying that those draft regulations, although it's not law yet in South Africa, we are entitled to go to court now, which we have done, and to challenge the publication of the draft regulations already. There's no use to go and comment and waste our times if the draft itself is unconstitutional. why the minister have incorporated change or draft regulations which are not only on that point but on other aspects as well, are totally in conflict with the act itself, the instructing act. We are just saying, and we are stopping that process, that she cannot go further than after the draft regulations. She must then actually, what she'd have to do, publish draft regulations again before she can actually lodge or to publish final regulations on that aspect. So we've decided that we're not going to wait. If it's invalid, if those the publication of that draft is invalid now, constitutionally invalid, there's no use to tell people go and comment and put in. There's no use for that because the entire process is flawed. So yes, thank you very much for all of you who did comment on that. It does show a solidarity in the approach, but at the end of the day, we have to be. We have to fight as quickly as possible, use the best way possible at that point in time. We cannot allow this the state any slack anymore. We have to attack them now and in their faces. To give them slack, to just reposition themselves and think about, okay, how are we going to sidestep the people again? Oh, no, sorry, those days are over. We've learned from the lockdown, and we're not going to repeat our mistakes. We've learned from our mistakes, and we are ready to fight the state on all spheres where they overreach their power. Now, for the interesting two cases that I've said in the beginning that we are also going to lodge soon. The first one is that we were made aware of the fact that John Steenhuisen has also made a decision about vaccinating our cattle for foot and mouth disease. The same principle applies. He had time actually until yesterday, Friday, to have provided us with his record on that decision. He also failed to do that. So we are taking him to court for that decision as well. And then the other one is a very interesting one that we are going to lodge against the South African Health Products Regulatory Authority. Many people do not know this, and frankly, I've also only figured it out relatively recently, that 3 out of the 4 COVID-19 vaccines that were registered up to date have been deregistered in silence by our state. So it means that 75% of the COVID-19 vaccines that we were forced to actually receive were found to be unfit for human consumption, human use. Why did the government not tell us that? Because of the fact that if anyone have received that, and I'm saying this, that by now that I'm of the view that everyone who have been vaccinated had an informed decision that they could have taken to vaccinate or not. Unfortunately, those who decided not to vaccinate were retaliated against. They've lost their jobs. They were discriminated against intensively. And so many of the people who and I do have a lot of respect for those people who decided, no, I'm not going, irrespective of that I'm going to lose my job. I know that I'm going to lose my job. I'm not going to be vaccinated. And it's now clear that all of them made the correct decision. All of those who have been vaccinated, by especially those 3 that have been deregistered, if you've got any strange ailment, I think that it's my advice at this point in time to go and consult your health practitioner, because there might be a very good chance that the ailment that you suddenly developed was a direct result of receiving those one of those 3 specifically deregistered vaccines. So that's my advice. But we are going to. We've asked for that record for deregistration. SAPRA have confirmed that there was an application made by each one of those 3 and to deregister. But the fact that it's an application, obviously there's a decision to have been taken, but they are trying to now say no, but we must go to the manufacturers, Pfizer, Johnson & Johnson, and then the LHC, I believe, yeah. That's, sorry, I forgot the other one. But in any event, the fact is that we are told that, oh, we must go to them. They've got the answers, and not SAPRA. SAPRA is the regulator, but they don't want to give us any information. Now we have to go to court to get that information. We'll keep you updated with everything. And yeah, let me just end it here. I'll make follow-up videos as I get the opportunity to do. I really want to thank each and everyone who have been and are supporting us financially or otherwise. Thank you very much. We really appreciate every single one of you, just by being there, and give us the encouragement to continue at times when we are also human, and many times I wake up and say that I don't have the energy for this anymore, but somehow from above and because of the encouragement that I receive from our supporters, I do go on, and I do what I believe should be done until the very end. Thank you very much. Join our YouTube channel. Consider becoming a member of it, and through that you can contribute financially, because we do receive quite a large part of those membership. And also, yes, join our social media, and do not forget to comment. We want your input on all of this, and without you, we can just as well stop what we're doing. Until the next time, God bless.
Liberty Fighters Network.
Liberty Fighters Network.